Hello, and welcome to the criminal justice system and DC. My name is Melissa Wasser, and I'm the policy counsel at the ACLU of DC. I'm excited to be hosting this conversation as a part of a series to talk about the priority issues we work on here at the ACLU of DC. We have been working very hard over the last year to develop a strategic framework, and we have identified 4 priority issues for our work. These are freedom from discrimination, criminal justice reform, the First Amendment, and statehood. Last September, we spoke at our membership meeting about freedom from discrimination, in particular, our work around the mental health crisis response in DC. And in November, we gave an overview of our First Amendment work. Today, we will be focusing on our work on criminal justice reform. The criminal justice system encompasses the entire process from being stopped by the police to being charged and convicted of a crime, to incarceration and after. The criminal justice process brings the full resources of the government against one singular individual. The founding fathers of our country recognized that this was a severe mismatch of power, and so they built fundamental individual protections into the Constitution. When the ACLU advocates for criminal legal reform, we are advocating for those individual rights, the fundamental political rights that protect all Americans from governmental abuse of power. There are many ways that our Constitution comes into play in the criminal justice system that I'm looking forward to explaining for you. But first, let me introduce 2 of my colleagues who will join in this discussion. Scott Michelman is our legal director, and Natasha Napper is our senior community organizer. Welcome.
Thanks, Melissa. Excited to be here.
Yeah, thank you so much, Melissa, for that opening, and really excited for this discussion today.
Great, I'm so glad y'all are here. So let's just get into it. The first entry that most individuals have into the criminal justice system is when they are stopped by police. The constitutional amendment that first comes into play in this moment is the Fourth Amendment. Scott, can you explain for us what the Fourth Amendment is and how it impacts people's everyday lives?
Sure. The police need a reason to believe an individual has committed or is about to commit a crime, what is legally called reasonable suspicion, to stop a person to begin with, whether they pull you over when driving or stop you on the sidewalk. And when police do stop you, they need additional justification to search you. And the searches must be conducted reasonably and concluded within a reasonable time. At the ACLU of DC, we have fought for individuals' rights every step of the way. For instance, we have sued where officers have engaged in searches and seizures without individualized suspicion. We represented one property owner whose yard police busted into based on a general description of a suspect nearby, even though that was based on little more than his race. We represented a guest at a friend's home who was searched because he happened to be there when the police were executing a warrant. We have sued over invasive searches where officers probed individuals' most sensitive body parts without justification. And we have sued where officers unlawfully prolonged a vehicle stop so that they could bring a drug dog to sniff the car, even though they had no reasonable suspicion to justify that. All the cases I've mentioned, by the way, resulted in court decisions or settlements in favor of our clients.
And I can also say that the ACLU continues to advocate for important limits on when police can stop someone. I testified back in December in opposition to Mayor Bowser's Act Now bill, which would, among many other problematic things, create unconstitutional zones that the mayor is calling drug-free zones. However, the Supreme Court has ruled that merely standing around in public or loitering cannot be a reason for the police to arrest you. These drug-free zones would essentially do just that, make loitering illegal, and that's why we took a position that that provision in the bill is unconstitutional. So regardless of the reason, when the police stop a person on the street, an individual still has rights. Natasha, can you give us a brief overview of those rights?
Yeah, thank you. When you are stopped by the police, you have the right to remain silent. You don't have to talk to the cops, and the Fifth Amendment in the Bill of Rights says that no individual has to be forced to incriminate themselves. You can say to a police officer, I choose to remain silent, or I'm exercising my Fifth Amendment rights. And it's incredibly important that when you do this, you actually stay silent. Scott mentioned the Fourth Amendment, which prevents unreasonable search and seizure. When a police officer stops you, you might ask they might ask to search your bag, and if you're driving, they may ask to search your car. You have the right to say, I do not consent to a search, and the police cannot search unless you have individualized suspicion. That is your Fourth Amendment right in action. Part of our work at the ACLU broadly, and the ACLU-D.C here specifically, is to go into schools and community spaces and to really do a deep dive with district residents about their rights in these moments when they're interacting with the police. If you're interested in a Know Your Rights training, we'll put that information up on the screen, and I and my colleagues, we would love to come and provide a training for you in person with your community group, your neighbors, whoever, to support you in knowing your rights.
That's great, Natasha. Thanks. And when we go into the community to give these Know Your Rights presentations, community members in turn tell us about their experiences. And one of the issues that has come up time and time again in the district is the racial disparity in police stops and police arrests. Natasha, you were part of the organizing effort to pass legislation here in DC in 2016 called the NEAR Act. Can you tell us how that law addressed racial disparity in police stops and arrests?
Yeah, absolutely. So the NEAR Act stands for the Neighborhood Engagement Achieves Results, which was passed back in 2019. It established the Office of Neighborhood Safety and Engagement, which focused on violence prevention and not simply responding to violence after the fact. It also required the Metropolitan Police Department, MPD, the DC Police, to collect data on the race of the people that they stopped. However, the MPD did not do this at first. In fact, they dragged their feet to the point for years, to the point of lying to the general public about whether they were doing it at all. The implementation of the NEAR Act is also an example of how the ACLU works in an integrated advocacy way. After the policy team campaigns to pass the bill, Scott and the legal team then had to sue the district in order to actually put the law into effect.
Yeah, astonishingly, it took more than 3 years after the bill passed for this to finally go into effect in 2019, after we won an injunction from a court against the police. Once MPD began collecting the data, the ACLU issued a report based on it, and it demonstrated what community members knew but hadn't had the data to prove, that MPD was disproportionately stopping and frisking Black people in the District of Columbia. Black people were 72% of those stopped in the district, even though Black people are only 46% of the DC population. Black youths made up 89% of the people under 18 who were stopped, and were stopped at 10 times the rate of their white peers. The NEAR Act data also showed that this broad pattern of stop and frisk around the city is ineffective. For the first 6 months we analyzed, over 11,000 stops were made that resulted in no warning, no ticket, no arrest. That almost certainly included people engaged in purely innocent conduct. And of the people who were stopped without any further action, 89% were Black.
I'll also add that since the passage of the NEAR Act, the policy team has continued to advocate during the annual budget process for the Office of Neighborhood Safety Engagement to be fully funded within the mayor's budget. It's another example of how the ACLU approaches an issue from all angles. We get community input into an issue, we lobby for a bill's passage, potentially bringing litigation to implement the new law, and then budget advocacy to fully fund it. So let's change tracks a little bit. We've talked about police interaction, but even after an individual is arrested, they still have rights granted to them by the Constitution.
That's right. Both the 5th and 14th Amendment entitle individuals to what's called due process of law, meaning fair procedures. And the 6th Amendment entitles people charged with crimes and facing jail time to be provided with lawyers to help defend themselves. Part of due process is to be held in humane conditions of confinement. As we'll discuss later when we talk about the DC jail, we've sued the district for holding people pre-trial without proper health and safety precautions. We've also challenged MPD's practice of holding for years or months the cell phones of arrestees, even if the phones aren't evidence, and even if MPD doesn't have a law enforcement need for them.
One of the fundamental truths that most Americans know about our criminal justice system is that even if you're charged with a crime, you are innocent until proven guilty. The consequences should be delivered only after officially being convicted of a criminal act. Natasha, can you explain how the presumption of innocence actually works in the district?
Yeah, Melissa, thank you. Unfortunately, in DC, many people who have not yet been found guilty of a crime are still incarcerated. Someone who has been arrested may be held in the DC jail while they're awaiting trial. This system in DC is called pretrial detention. It is a severe restriction on an individual's liberty, and in a free society, should be used incredibly rarely. Recently, we opposed two bills before the DC Council, which would have expanded pretrial detention. For example, a young person can be incarcerated pre-trial in order to ensure the child's presence at their hearing or for the protection of another person or the other person's property. The Safer, Stronger Amendment Act would expand that criteria so that a child could be held to protect their own property or themselves. In other words, a young person could be incarcerated for their own good, so even if they are not a threat to others. The proposed active act, another bill that I want to talk about, also would make it harder for judges to release people accused of certain crimes. Again, if the purpose of these bills is to reduce crime, expanding pretrial detention would be ineffective in doing this. And 92% of people released from pretrial are not rearrested, and only 1% are rearrested for a violent offense while awaiting trial. However, unnecessary detention, even for periods as short as a week, can and do increase a person's probability of rearrest. Just 3 days in jail can upend someone's entire life. And they can lose their job, their home, custody of their children, all without having actually been convicted of any crime at all.
And although DC doesn't have a bail system, which also places another financial burden on defendants before they've ever been convicted of a crime, our local system of pretrial detention has deep ramifications, as Natasha explained, on residents' lives, particularly Black residents. And I want to turn now to the actual conviction. What a person can be convicted for doing depends on what conduct is labeled as criminal in the first place. So, Scott and Natasha, I'm interested to hear from you both about how the ACLU has helped in redefining what is criminal conduct within the district.
Several years ago, our community partners pushed to decriminalize possession of marijuana and established a legal system to buy and sell it. An ACLU report had found that in DC, Black residents were 8 times more likely to be arrested for marijuana-related offenses than white residents. Decriminalization did occur, and now it's legal under DC law to possess up to 2 ounces of marijuana, grow it yourself, and consume it on private property. However, marijuana is still criminal under federal law. In addition, every bill that the DC Council passes goes to Congress for its review. This does not happen for local laws passed in any of the states. The aftermath of congressional review on marijuana was that DC was allowed to decriminalize marijuana, but not implement the legalization of buying and selling it as a product. As a result, DC has missed out on tax revenue that other states have garnered from their changing their own marijuana laws.
And I want to underscore the challenges that DC faces in having our local criminal code go under congressional review. Yet another example, last year, the DC Council passed a comprehensive reform of our criminal code after 12 years of analysis, side by side comparisons to other jurisdictions, and input from a vast array of community members and law enforcement. Unfortunately, Congress overturned that local bill despite the ACLU's strong objections to their interference. There is so much more to say on that subject, but I think we can save that for our next event, which will be on DC statehood. But meanwhile, Natasha, I'd like to hear any examples you may have of how this implication of the Eighth Amendment means criminal charges have changed over time.
Absolutely. One recent example of this has been the fight to decriminalize street vending here in DC. If you're a resident of the district, you're probably familiar with street vendors in your neighborhood. I know that I am, and they're very near and dear to my heart. Vending has been a part of DC culture for such a long time, for generations. But up until recently, street vending licenses were to obtain, and anyone who risked vending without a license could face steep fines and even criminal charges. Now, it's important to also note that here in DC, a majority of vendors are Black and immigrant community members. And should also be noted that street vending has been a risk to public safety. Regardless of this, many vendors, the majority of whom were coming from and are coming from marginalized communities, were harassed day in and day out by police, often with devastating impacts on their lives and livelihoods. We were able to advocate in a coalition, including Vendedores Unidos, also known as Vendors United, and as of July of 2023, street vending is decriminalized in Washington, D.C. And the pathways to getting a vending license are considerably easier, allowing our community members to operate in relative peace.
That's great. The Eighth Amendment is also where the Constitution prohibits cruel and unusual punishment. In DC, after an individual is stopped by the police, arrested, charged with a crime, and if convicted, they may be incarcerated as part of their criminal sentencing. Natasha, can you give an overview of how incarceration works for DC residents?
Yeah, when an individual in DC is first detained, they are incarcerated in the DC jail, a term we often use to refer to two facilities in Eastern Ward 6, the Central Detention Facility, or CDF, and the Correctional Treatment Facility, or CTF. These facilities together often house anywhere between 1,000 to 1,500 people at any given time. They hold a combination of pretrial detainees and people serving custodial sentences of up to 1 year. Because DC is not a state, we don't have full control over our prison system. DC residents serving longer terms in custody go into the custody of the Federal Bureau of Prisons, BOP, which sends residents to federal facilities anywhere around the country. Oversight of BOPs rests with Congress, where DC residents have no voting representation. More on that in a future meeting when we discuss statehood, as we previously mentioned. But I also want to note that ultimately these residents will return home to DC after the completion of their sentence. Maintaining personal relationships is critical to reintegrating after incarceration. However, being placed at such great distance severely limits visits from friends and family and other community members, and this puts it puts those incarcerated at greater risk for recidivism or rearrest and conviction. And as part of the ACLU's effort to fight mass incarceration of the district, we will need to address the factors that structurally increase incidence of reincarceration.
And Natasha, I heard you mention the DC jail, and we frequently use the full force and power of the ACLU to insist on humane conditions at the DC jail. Last spring, I testified during the DC Council performance oversight process on the Department of Corrections, and this is something we're going to repeat again this spring. We've also filed litigation against the Department of Corrections. Scott, can you update us on recent efforts that the legal department has taken to ensure adequate conditions at the DC jail?
We filed several lawsuits during the pandemic regarding unsanitary conditions in custodial facilities at the DC jail and other related facilities, like a federal halfway house in DC and DC Psychiatric Hospital, where people are sent when found not competent to stand trial. When the COVID-19 pandemic hit in March 2020, the DC jail lacked any sort of implementation plan to keep its residents safe from the dangerous spread of COVID. Basic sanitation measures were absent, and medical requests from people in custody were ignored for days. We, along with the Public Defender Service of DC and the law firm of Munger, Tolles & Olson, took them to court and won an injunction requiring improvements. The injunction was in place for more than a year, and after that, we settled the case in exchange for a promise to make further improvements, backed up by in-person inspections by experts. In our fight for humane conditions, we find common ground with folks we don't always agree with. Even the DC Jail Guards Union supported our COVID conditions lawsuit because DC's disregard for basic sanitation put their members at risk too. More recently, we sued on behalf of a transgender woman who was placed in the men's unit at the DC jail in our case Hinton versus District of Columbia. We represented Sunday Hinton, a trans woman who was housed in the men's section of the jail for weeks in the spring of 2021 after being ordered detained pretrial on a petty theft charge that was later dismissed. Days after we filed our case, Ms. Hinton was moved to the women's unit, and weeks later, the DC jail again changed its policies, presuming to house trans residents in accordance with their anatomy rather than their gender identity, showing how effective our litigation can be in forcing basic changes to recognize the humanity of people in custody. The case continued after these changes because DOC decided to house transgender people in protective custody, where they were isolated and where they were at times being shackled when moved within the jail. Here too, DC eventually settled, agreeing to change its policies. Although we are troubled by reports that trans people in custody continued today to be housed at odds with their gender identity, and we continue to monitor that situation. We also filed suit against the Department of Corrections for its refusal to provide kosher meals to Jews in custody without proof of their faith, such as by a letter of conversion, even though such strict requirements are unlawful and weren't required of individuals of other faiths. Again, DC changed its policies in response to our lawsuit.
Thank you so much for talking about this, Scott. I do want to take a moment here to point out to our viewers that the Public Defender Service does have a helpful reentry guide if you or anyone you know is a returning citizen. As you can hopefully see, the ACLU is invested in protecting the rights of anyone involved in the criminal justice system, from that very first interaction with the police all the way through incarceration and reentry back into society. Each of these positions is grounded in the Constitution and in the Bill of Rights. I'd like to thank again Scott and Natasha for a great conversation today.
Thank you for hosting. It was a pleasure.
Thank you so much, Melissa. This was great.
Thanks everybody so much for being here. If you'd like any more information about the ACLU of DC, you can check out our website at aclu-dc.org.